There you are. House Energy Policy Committee will come to order. Clerk, please call the roll.
Chairman Glenn.
Here.
Representatives Houck.
Here.
Barrett. Cole.
Here.
Tedder.
Here.
Bellino.
Here.
Farrington.
Here.
Griffin.
Here.
Johnson.
Here.
LaFave.
Here.
Lauer. Riley.
Here.
Lozinski. Here. Deanda. Garrett. Camilleri. Elder. Green.
Here.
Sneller.
Here.
Mr. Chair, you have a quorum.
Thank you, Madam Clerk. Need a motion to approve the minutes of last week's meeting. Representative LaFave so moves. Without objection, so ordered. And members of the committee, appreciate you being here at 8:30. We have a news conference at 10 o'clock on an insurance issue that a lot of people want to attend. But we have, at the request and recommendation of Representative Griffin some weeks ago, we have Jim Ault and Laura Chappelle, who have put together a presentation. And if I understand correctly, Jim, you think it'll take 3 different sessions?
I'm thinking, in talking with Laura as we were preparing, we were kind of hoping to do it in 2.
Okay.
But I think we'll have to see how it goes. As you get into the current acts, it's
Right.
much more complex.
And it'll be determined by the questions of committee members. But here's the opportunity to be briefed from people who may not agree on what the law should say. In fact, we tried to get somebody on both sides, and they both accepted the responsibility of presenting it to us in a neutral fashion of not what the law should be, but what it is. So a primer, I understand we're going all the way back to the 19th century, so I'm told. And Laura had an emergency situation and not able to join us this morning. We hope she'll be able to join us in the next hearing or third if it goes that long. So Jim, I want you to leave plenty of time for questions in each of these sessions. So however you want to do it, 45-minute presentation, remainder for questions. And committee members, we're going to adjourn the committee at about 10 till 10. So we're not going to get quite 90 minutes in, probably about 80, and at this point 75. So
If we go longer, I mean, if we don't get it all in today, I mean, we can pick up at the next session depending on...
Right, but I want you to make sure to leave time for questions, because I don't want them to have, committee members to have to wait a week to ask you a question based on something you say today.
Okay, and I think also, I'm open to having you interrupt and ask questions
Okay,
as we
great.
go.
All right, with no further ado there, Jim, if you would proceed.
Okay, and thank you for allowing us to come in and testify on this. This grew out of some discussions with about Laura and I used to teach an energy law class at Cooley, and it kind of started with that, and then here we are. And so I thought for the beginning, when we were asked really to talk about the current acts, but to also educate the committee, one of the difficulties is you can't really understand the current acts without going all the way back to 1909, basically, because in Michigan we're dealing with statutes that have been on the books for that long and remain effective and active today. So what I thought I'd do this first day is kind of take you through the history, kind of overlaying what was going on with the development of the utility industry all through the 20th century, and then kind of where Michigan kicked in with some of their statutory provisions, all of which have relevance today, as a lead up to the Acts 341 and 342. And I had a couple of quick overview slides to kind of, this is supposed to be educational, and as you know, the industry participants group on this slide are the investor-owned utilities. That's the DTE, consumers, and I actually, my association, Michigan Electric and Gas Association, is of IOUs, as we call ourselves, and we're the smaller ones, SEMCO, MGU, the Upper Peninsula Electrics and Gas, Alpena Power, and then of course Indiana Michigan Power, AEP. Not all small utilities by any means, but in Michigan, yes. The municipals actually all started there, and they continue today with Lansing Board of Water and Light right here, and the rural electric cooperatives from the 30s and continue active in Michigan today. There's 9 of the distribution cooperatives. Those are the 3 that kind of go way back in the history, those 3 players. There are others, but Each one has its own type of regulation. Right now, the MPSC would regulate the IOUs, rates, and services. The municipals are regulated at the local level by their governing boards, and there's various structures for that. Rural electric cooperatives are now member regulated, but for a long time they were regulated by the Public Service Commission for rates and service, and there's still some service regulation there. All three categories in Michigan exist, and they're all monopolies, to use one of the chairman's favorite terms. And the type of regulation is what differs among the three groups. The last category, I just kind of put that in. These are not yesterday so much as recent, are the regional transmission organizations, the independent transmission providers. Transmission used to be part of the vertical integration of utilities. PURPA QFs, now there's a term for all of you to enjoy, Public Utility Regulatory Policies Act qualifying facilities. And that came out of the Jimmy Carter era energy legislation, and those are smaller producers of electricity that are independent of the utilities. And there's about 45 contracts in Michigan. We're going to talk about that later. Other NUGs, NUG just means not, there's lots of acronyms, and I'll try not to use too many, non-utility generators. And that could be like a paper mill in the UP that has its own generation. Cogeneration is in industry, commonplace for that. And power marketers, that's the AESs and that are brokers of power and come into the state to market in the choice market and in the wholesale markets. So that's the industry makeup. There's been already talk at this committee of the federal-state issue and the regulatory. I call this the regulation divide, and the dividing line is not all that clear as you're learning. But I thought I'd throw in the basics here. Of this, and this goes back to the early days of regulation as well. But the U.S. Constitution, Article 1, Section 8, interstate power, or the Commerce Clause, which gives the power over interstate commerce to Congress, and then the Supremacy Clause, if Congress acts, that's the supreme law of the land, Article 7, and then the Dormant Commerce Clause, which is something that comes up quite a bit in this industry. If it's a matter of interstate commerce and commerce has not acted in that area, the states are still not able to act because the power is a federal power. And where the line is on that is a matter that we may get into later, particularly when we talk about the current acts, but there's some issues on that, one of which being like the territorial footprint for renewable energy, limiting that to the state or near the state. You know, and that's interstate commerce. That's Judge Posner has opined on that, and that's the kind of thing you get with the Dormant Commerce Clause. So the dividing, though, by federal statute, the Federal Power Act from the 1930s, the federal regulation for electricity is wholesale and interstate transactions. That's federal jurisdiction. The states regulate retail rates for service, and then I put this kind of phrase in there, matters primarily of state concern, which that gets you into some of the arguments, where do you draw that line? And I'm not going to go there today in this historical review, but we might talk about that more later. But the basic dividing line is the wholesale, interstate versus retail in terms of the state authority, and that's via the Public Service Commission. These are really a pretty significant point, the traditional regulatory principles. We used to teach this in the law class quite a bit, actually, and there's court cases, Supreme Court precedent, lots of things that go into this. But I thought when you talk about monopoly, vertically integrated utilities, which has been the tradition, these are the principles that generally across the country have applied, and includes Michigan. So you have kind of the basic just and reasonable. You hear that a lot in utility law, the rate's just and reasonable. And then non-discriminatory rates, meaning if you have, this grew out of railroad rate discrimination against favored customers and that type of thing. Utilities are supposed to charge like situated customers the same rates. They can't deviate for that. You hear a lot about the regulatory compact and the duty to serve. That's the second item. And basically that's the trade-off that grew out of a lot of different case law and statutory law. But the utility The government sanctions monopoly. That's what you're talking about with the regulatory compact. But in exchange for that, the utility gives up, the control of its pricing to the government, which regulates that. And the purpose of that regulation has always been to kind of be a surrogate for what a competitive market would require. And these apply in Michigan as well. The constitutional Fifth Amendment and 14th Amendment to the state's takings clauses, basically, those in utility world kind of come in, and there's a series of cases. I think Hope Natural Gas, Bluefield Water Works are famous U.S. Supreme Court cases that talk about, that you can't take private property for public use without just compensation, and that goes to the return allowed on the utility investment in their physical assets, that investors put up money, they build power plants, and a regulator can't just throw that out and deny recovery without possibly running into these constitutional takings prohibition. Natural monopoly theory is right at the heart of even some of the things that are going on today in the debate about generation and the competitiveness of it. But basically the economic theory of that is a firm is able to grow larger and keep decreasing its prices until it ends up as the only provider. And the benefit of that to customers is that your rates are going down, not up, and you're going to see in some of this history in a few minutes that that actually happened. But at the same time, you end up with a single provider monopoly, and that's not always favored for a lot of reasons, and that relate a lot of cases to individual situations. And part of that analysis, in natural monopoly theory is that if you, take utilities, cable companies, for example, if you have, the trend would be toward one giant cable provider with its network, because its network or grid, and we'd call it the grid in the electric world, it can serve additional customers with virtually no additional cost. So as you add those customers, you're spreading the majority of the costs or fixed costs of the industry, it's high, over more and more customers, which allows you to lower the rate per customer. And it also blocks competition in a sense, because the entry costs are so high to duplicate that grid. And then, as we'll see in a statute in Michigan in a few minutes, it's considered kind of wasteful to duplicate those kinds of assets. And so even with competition today, you see they preserved local distribution as a monopoly type service, and then it was generation where the effort has been made and is being made to introduce competition. This last point on here, I know, boring formula, that's the basic rate making formula that our commission applies when they do cost of service rate making, and it's pretty much common across the country because cost of service rate making is quite commonly used. So the revenue requirement, that's the R in there, is basically determined in cases where you look at the operating expenses of the utility, and the small r at the end is the return, whatever that is. It's a blend of your equity and your borrowing return, your debt return, times the undepreciated rate base, which is V, which is value of your assets, minus the D, which is depreciation. So you take what's left, the undepreciated amount, and you apply the rate of return to that for the earnings, basically, of a utility. So a lot of the expenses in the O category. But that formula, Michigan uses it. We're not required to use it, absolutely, but that's what they've traditionally been doing. I'm going to now start to go back a little bit. I want to talk about how the grid came to be, because it's such a fascinating story. And when I did this, getting ready for this testimony, I looked at this again, and I thought, wow, these are leading to some of the same debates we're having now, what was going on in the early days of the industry, which was really heavily influenced by these four characters on the slide. And I've got, I should have said this at the beginning, I've given you an outline that has a lot of the detail in it, what I'm talking about, and the slides are a little less detailed, so if you want to follow along, I wanted you to have an outline that you could keep, to refer to the statutes and things like that, without doing necessarily a slide on every one. But these are two businessmen and two entrepreneurs, and up in the center of the top is Thomas Alva Edison, pretty much the one that developed incandescent light bulbs connected in series, which were the very start of the electric utility business. The Pearl Street, New York was one of the very first. I think there was one earlier in San Francisco, but it was called Brush. They used arc lighting too in the early days. But Pearl Street, New York was mammoth steam generators, 6 of them, to light 1,200 lamps that were then sold in the business district, basically. And then Edison licensed that system. And you get, for example, you'll hear Detroit Edison in Michigan, Commonwealth Edison. These were all companies that started by licensing Thomas Edison's original grid kits, basically. And one of the distinctions in those original ones, they used direct current, which had a very low travel ability, so you limited the range of your distribution system to within, say, a mile of the generating station. And that, I'm going to talk about that with Tesla. Because Tesla, Nikola Tesla, and that's the Tesla of the automobile named after, was quite an inventor, worked for Edison. Edison's lab was sort of the start of all of this. But he developed the polyphase alternating current electric generator, which really transformed everything back in the early days. Polyphase just means it's a little more powerful. If you remember your sine wave from high school that looks like this, and you overlay 3 of them, that would be 3-phase, up and down, because alternating current, you're swinging back and forth 60 cycles per second today. But you overlay 3 of those, you get a lot more boost from your power, and that's what Tesla developed, an electric generator. George Westinghouse, and that's another name that goes long in history, Westinghouse Electric. He developed the first. He bought Tesla's patent rights and developed the first alternating current grids. There was one in Massachusetts, and then eventually the big item there, alternating current allows long distance transmission, and it also allows transformers, and this is all the technology today still. Transformers can take 1 voltage of alternating current, and you wrap the wires around one end of a magnet that's kind of a loop, and then wrap a different number of windings around the other end, you get a different voltage. So you can move current up or down. And it allowed long distance transmission, and that's still the basis of transmission today. And so when they built an AC power plant at Niagara Falls using hydropower, they transmitted the power by transmission lines to Buffalo, New York, which became the foundation for Buffalo becoming a huge economic development area in those days. That's Westinghouse and Tesla alternating current. Sam Insull, this is the guy, and it's a tragic story in a way, and it's a fantastic story. If you ever read, there's books about Insull. But he started in Edison's lab. He went to Chicago, and he founded Commonwealth Edison, which, the Chicago Edison, took that over, but of course developed all of the kind of concepts that are in the modern utility system today in the early 1900s. So I listed a few of them in the outline, like the model of vertical integration. He started consolidating. I mean, in those days it was kind of a jumble of different, you had AC systems, DC systems, you had very small systems. In downtown Chicago alone there would be multiple systems, and everywhere the industry was developing. He started buying them up and then developed vertical integration where the same company would control the production and the supply and distribution, generation. Economies of scale were huge with Insull's systems. He developed demand and time metering. There was something called the Wright demand meter that was invented in England that came over where you could measure the time of use and the maximum demand of a customer, which is kind of right at the heart of utility billing today. The 2-part rate, which is demand rates to cover capacity costs by large users, came out of Insull's work. And growth and demand diversity. I couldn't say enough about this because they were, in the early days, electricity was for downtown business district lighting and maybe some traction companies. And so, and of course, you can just think about that. Your demand is going to be very concentrated in time. In the evening, late afternoon.
Traction companies?
Traction, trolleys, streetcars, that type of thing. And in fact, the L, you know, Commonwealth Edison getting the L contract to run the Chicago L, what it did was spread out the demand over more hours so you could run your plants more efficiently. And these are coal plants at the beginning, steam plants, and steam turbines come into this. So Edison had a great quote, and I thought this quote was relevant today. Back then he said, if your entire plant, and I think he had one called the Adams Street plant, which was his first kind of big central station plant in Chicago. If your entire plant is only in use 5.5% of the time, it's only a question of when you'll be in the hands of a receiver. I mean, you're on the path to bankruptcy because you got this expensive asset and you're utilizing it just a tiny fraction of the time. So Commonwealth Edison under Insull would promote electric growth, something that we're kind of on the other end of that now today, you know, with conservation and you know, cutting usage. They promoted it to make these plants run more efficiently and make more money, grow the industry. So it was a whole different outlook. And one of the things in one of the readings I did was looking at, they used to send trucks and wagons out into the neighborhoods of Chicago giving away steam irons for household use that would run off of electricity. They'd screw into the light bulb socket. And that was a way to promote more demand. I'm going to switch to, that's some of the early infrastructure on this slide. The Pearl Street plant in New York is the one on the right. And the dynamo, there were 6 of these jumbos, they called them, that was a generator, is in the upper part of that slide. And then below that's the AC polyphase generator, the first one that was a major one. So I'm going to start. I'm going to start Michigan, but before I do that, I'm going to talk about 1897 to 1907. This is all happening in the late 1800s. Insul's into the next century, but the beginnings of the industry. And so you've got the competing types of local system, AC and DC, often municipally owned because you're dealing with downtown business districts, lighting for the commercial sector only pretty much, and maybe the traction as part of that. And so a lot of these were municipal, and they'd buy these grid kits from Westinghouse for AC or Edison for DC and own them. And I got a quote in there from Gretchen Bakke. She wrote a book called The Grid, which I've included in the outline. It's a current book. I think it was last year. Excellent historical view of this industry, and it's written for the normal reader, not too technical. It's a great review of the history. She says the electricity business might have been a chaotic diversity of competing interests and alternate systems in the final decades of the 19th century, but what happened, the battle of the currents, AC versus DC, was resolved in favor of the 60 cycles per second, or hertz, polyphase AC system. So that everything started to converge on that. Steam reciprocating generators had started. That's like a piston engine. But then eventually you develop these other devices, rotary and phase converters, AC to DC, power conversion transformers to change the voltage for transmission, and the polyphase system, which gives you a little more power. And so the competition then was with candles and gas. There were extensive municipal gas systems, gas lighting systems for public lighting, candles and gas in the home, gas lamps, and the electricity started to displace that in these early years. So the beginnings of regulation occurred, and this first it was primarily municipal government that would regulate the utility business. And the way they did that, and they still do this today, the franchises, which are in the Michigan Constitution, a private utility has to have a franchise to do business in any municipality, a township, city. So utilities or municipalities would use those in the early days, and they'd award competitive franchises to different operators, and then that would control rates, or they'd enter into long-term rate agreements as part of the franchise deal with the provider to set the rates. We actually, in MEGA, my organization, we still have 2 members that are regulated at the municipal level, even though they're investor-owned. Little Aurora Gas up in Onaway, Michigan, home rule, they call it under the statute, and then Citizens Gas of Adrian, Michigan. They have a local gas rate commission, but they're investor-owned utilities, different from the Lansing Board. regulated at the local level. So there's a little, that's sort of a last remnant of this system. But as the utility systems grew beyond the municipal limits, the municipal regulations started to change. And at the same time, you had the national progressive movement that was going on, where there was a lot of concern because of railroad history, particularly over natural monopolies. And even municipal issues, patronage and things like that, or keeping the rates too low to curry votes, that type of thing. All those were matters of concern, which led to the beginnings of state regulation, which precede federal regulation. In 1907, New York, Wisconsin, and Georgia all adopted state commission regulation by statute. And they use the model of a commission, which we use here in Michigan, is based on the old Interstate Commerce Commission, which grew out of the railroad business at the federal level. And it grew rapidly. So they started in 1907. By 1914, 33 states had it, and today all states have that type of a form of commission regulation. The municipal utilities continued to be a pretty major part of the industry in the early years, reaching 2,500 of them by 1922, but it declined after that, mainly because you've got bigger service territories and municipal boundaries. And Insull, going back to Sam Insull, was an advocate of this regulation because he viewed it as providing the kind of stability you'd need to preserve low-cost, long-term financing for the massive capital investments that were required to expand the utility business in those days. So Michigan was not far behind. We were one of the early ones in getting into this. In 1909, we started with a trio of statutes that kind of worked together. The Michigan Railroad Act, 1909, PA 300, still on the books today. The Utility Securities Act, 1909, PA 144, which has been repealed, not until 1995 though, and the I'll call it the Electric Transmission Through Highways Act, 1909, PA 106, all came in that year. And what they had here is a 3-member railroad commission, the Michigan Railroad Commission. 2 members had to be from the same political party. The government appoints the 3 commissioners, 6-year terms, and qualifications, which I know has been of interest to the chair. They had, you had to have, it was mainly transit related because of the railroad regulation, but you had to have all 3 with experience in that and 1 attorney of the 3 under that statute. Some of the concepts in the Act 300 were railroad concept that got translated over to the utilities. Common carrier duty to serve, and the utilities have a duty to serve. The prohibition against discriminatory rates. At the same time, even though it was called a railroad commission, Act 106 brings electricity into it right away, right from the beginning. And the way that statute's almost entirely still on the books today, so it's relevant. Act 106. So it talks of regulating electricity generated in one county and delivered in the same or another county. And that wording is still there. So some of the elements of that, going back to that slide I had earlier about the basics of regulation, some of the fundamental concepts. Prior commission approval of electric rates. There's a section that preserves local control, and that's this is in the Constitution. The municipalities reserve the right to local control of their streets and public ways, whatever they are, alleys, streets. And then they also have the right to, you have to have a franchise to do business within their jurisdiction. That's protected often by, the statute just reflects the Constitution in that regard. Then this Act 106 goes on to authorize the fixing of rates on complaint. It has the just and reasonable standard that's so common in utility law, prohibits discrimination among similarly situated customers, authorizes rulemaking, and one of the ones that it refers to court appeals pursuant to Act 300, and I'm going to get to that in a minute. Act 106 also talks about elements to consider in setting the price of electricity: the cost, return, depreciation, obsolescence, business risk, connected load, value of service. Value of service, that has a lot of potential meaning, and hours and quantity. And that's a little more than that formula that we talked about earlier. But those terms are all contained in this act, and it's still on the books. So what's left today? The Act 144 securities regulation, where the utility had to go to the commission and obtain prior approval to issue stocks, bonds, and evidences of indebtedness, that lasted until 1995, and then it was repealed. It's pretty much redundant to both state blue sky securities regulation and federal securities regulation. A lot of Act 300, a lot of relating to railroads is still on the books. Probably the biggest section there, I think, as a lawyer, I did a lot of law practice prior to my time at Mega, and the 30-day right to appeal, which we use today, that gives the right to appeal from Public Service Commission orders, is in Act 300, even today. And so it used to be that appeal went to the circuit courts, and in my first days of working in this business as a lawyer, we would take appeals from the commission to the Ingham Circuit Court, and they didn't like that because they always got appealed up to the next level anyway. So in 1987, that was changed, so the appeals now go directly to the Michigan Court of Appeals, and that continues today. So it seemed odd to start with a 1909 law, but so much of this remains on the books, and in your outline you've got kind of these parts of it to consider. There was it didn't last real long until there was a major change in Michigan, and it's another law that parts of it remain on the books today, and that's 1919 Public Act 419. That abolished the Railroad Commission and replaced it with an entity called the Michigan Public Utilities Commission. And you see around the state, you'll see like Public Service Commission, Public Utilities Commission. Those terms are going to be used, interchangeably a lot to mean the same thing. Now this commission, the Public Utilities Commission, 5 members, governor appoints, 4-year terms, but the other qualifications were taken out, and they've not come back. The attorney, the knowledge in the industry, those qualifications are gone. This statute focused more on public utility service, away from the railroad service, which eventually went to the Department of Transportation, and I'm not going to go down that history, but it added gas, the gas utility business, and provides for the fixing of rates, the ability of the commission to get financial reporting and other reporting, accounting from the utilities. There was a practice where every time they did one of these reforms, because there's another one that comes up not too long, they would transfer all the powers held by the prior body to the new one. So it kind of continued, 1909, 1919, then it'll be 1939, it'll be the next one. So that's what was going on there. And I'll talk about another statute that I think I wanted to get to. I want to get to 1919. I guess I've covered the 1919 one. Hang on a minute. Let's see where I am here. I do want to cover this before the Depression era, which is going to shift me back to the natural history. This statute, I think, is of a lot of interest today. It's remained on the books ever since 1929. This is the statute. Some states, the commission would license service territories, and utilities would have their monopoly service in a designated territory. In Michigan, it kind of developed on a more ad hoc basis, and this statute, 1929 PA 69, is the one that protects the borders in a sense of a utility service territory. And to give you an example of how it works, you have to have your municipal franchise anyway. Say let's just take a hypothetical township that's being served in one part by Consumers Energy, and another utility's on the border, the opposite border with a nearby system. They would have to, in that township, they'd have to get a franchise, so you'd have 2 franchises for the township, and they would have to go to the commission, get a certificate under this act to serve in that township, because you've got another utility already serving, even if they're only in a part of it. And these cases come up from time to time. But absent a certificate, you can't render the service under this statute in a township, and this is a Public Service Commission action that applies. So this is the border control, I guess you'd call it, in one sense, of public utility monopoly service territories that you don't have utility versus utility competition. Now, we have on the borders that between co-ops and IOUs, for example, there's a commission rule that applies called Rule 411 that, when you have two borders of utility service territories touching, the customers can sometimes choose within a narrow sphere, and then municipalities, they govern themselves. We just had a Supreme Court case on this, that they're not under Rule 411, but that's part of it too. So that's it's an important statute today. I want to back up and refer in the outline, I don't have it on the slides, I talked about three other statutes that kind of go back to this 1920s era. Interest on guaranteed deposits, this is on page 4 of the outline. That's the statute that allows a utility to require a deposit from ratepayers under terms and conditions approved by the Public Service Commission. Still in effect today. There's rulemaking on this that are in effect where you can, if you have a customer with a bad credit history or bad payment history, you can require a deposit as a condition of restoring service, and the interest rate, we got a pending rulemaking now, it was at 7%, it's going to 5% if the rules go through. So that statute's still on the books. Rehearings, 1923 Public Act 94, still on the books. That authorized the Public Utility Commission at the time to grant rehearings and amend their orders, and that stays on the books today as applied to the Public Service Commission. And in fact, the AG just filed a request for rehearing in a case we're involved in where it's beyond the 30-day time, but they cite the statute as authorizing that kind of a rehearing petition to correct the commission order, sort of as an ongoing matter.
Jim, Representative Lefebvre has a question.
Yes.
Thank you, Mr. Chairman. Thank you for testifying. My question was, how much can the deposit be if I have really bad credit?
It's set in the rules, actually. I can't remember exactly. It's something like your average monthly bill. It's in the actual administrative rules that the commission has. So it's not it can't be indefinite amount.
Sure, but it could be about a month.
Yeah.
Okay. Thank you.
Now this third one.
Jim, Representative Griffin?
Oh, sorry.
Thank you, Mr. Chair. You threw something at me that I couldn't gather. I'm on page 5. I'm on the third bullet on the current slide that's up before us. It says, you threw something about Rule 411 that I think it has to do with the third bullet. Can you give me what Rule 411 is? Because I tried to go back and find it, and then I got lost between the last two slides, so.
Okay, yeah, that's part of my confusion on doing the slide deck quickly.
No, I appreciate it, but thanks.
Rule 411, Act 69 deals with townships, municipalities, when there's more, another utility wants to enter where an existing utility is serving. Rule 411 is a commission rule that was developed basically for convenience and the customer, where you have two utilities that their borders bump up against each other, which occurs all over the state, and a customer can look at which two is, say, closest. There's provisions in the rule about if it's within, I'll say 100 feet. I don't know these exactly without looking it up, but if it's within a certain distance, a customer can choose utility A or utility B. And that's between two IOUs or between an IOU and a co-op. And we just had a battle that went to the Supreme Court as sort of a derivative of a case called Great Wolf Lodge, which I won't get into that now, but they kind of confirmed that Rule 411 doesn't apply to municipal utilities because they're not regulated by the commission. They can't be under a commission rule. So I hope that helps.
Jim, who was arguing that the municipals were under the PSC? I mean, who was
Actually, the Supreme Court somewhat did that in this case called Great Wolf Lodge, where they applied Rule 411 by analogy to the customer in a situation. Great Wolf Lodge is in Traverse City. It's on the 31 coming south. And at one time there was a battle royal there over whether the municipal utility, Traverse City Light and Power, consumers, or Cherryland Co-op would serve it. And this went to the court, bounced up and down to the courts, the commission, and it got to the Supreme Court, and they had said that they had applied kind of a no-switch rule to the customer, citing Rule 11. And that's what in a subsequent case, the one that was recently decided, was thrown out. They, the court, it was kind of in a dicta statement too, but it was being cited and used, and the Supreme Court went back and looked and said, no, that's not right. Municipals aren't regulated by the commission, so they're not under Rule 411.
Representative Griffin?
You just answered the follow-up. We're good.
Representative LaFave?
I'm sorry, can we contextualize this, what the ruling was in both of those? Basically, I've got a camp out in northern Delta County. I'm 20 miles away from a municipal, and I'm also 20 miles away from an IOU. Under this new Supreme Court ruling, I wouldn't be able to choose the municipal, or even what if I was 10 minutes away or 100 feet.
You're in Delta County, and you've got
Dickinson, sorry.
Dickinson County, and you've got the co-op then, and a municipal utility.
Or an IOU. Basically, I'm not certain.
20 miles is way beyond the scope of Rule 411.
Yeah, I have.
Rule 411, it's very close situations.
No one delivers me electricity at all right there. So, would I be able to go, what if it was 100 feet to a municipal versus 100 feet to an IOU? Under the Supreme Court ruling, would I not be able to choose the municipal?
The municipal wouldn't be covered by the rule at all. So the question would then become, who's got the right to serve you, with the franchise in that district? And then probably the issue you're going to have in your situation is who's going to pay for the extension of service to a single customer, and probably in either case they would apply that to you, and that would make it kind of not very cost effective to get the extension of service unless you could find something closer. We're going to go back into the history part of this again. And how are we doing on time?
35 minutes.
Okay.
35 minutes to go.
Depression era. Huge era with industry growth pretty much continued through the Great Depression. It didn't really stop it. It slowed it down some, but you had, let me get to that. You had the beginnings of federal regulation of the electricity business occurred during the Depression, and I'll run through. These are in the outline. I don't have a slide per se of them, but well, maybe I do. Nope. It started with the Public Utility Holding Company Act of 1935, and what that was aimed at was Sam Insull was I guess you'd call him the culprit in the historical sense. He had developed like these holding companies that basically grabbed control of the entire utility business under a holding company structure, and so one stock entity could control like utilities all over the country, and it narrowed the control to like say 11, the exact number, but a small number of entities controlling the entire U.S. Investor-owned utility system. And when the Depression hit, of course, it ruined it because you had enough of a financial effect there. It caused bankruptcies, total wiped out shareholder value all across the country, and wiped out Insull. He ended up dying poor in Paris after being brought, criminal charges brought against him for the financial fraud that happened. I mean, it's quite an interesting story, but that led to the Federal Public Utility Holding Company Act of 1935, which really restricted the ability to form these giant conglomerate holding companies. You had to have a contiguous connection. The utilities had to be closely connected in order to get approval under that act, and the SEC would regulate that. The Federal Power Act of 1935, that was the main federal statute that started federal electricity regulation. Prior to that, the Federal Power Commission regulated federal hydroelectric projects, but they expanded their authority to include the wholesale electricity transactions that I talked about earlier, interstate wholesale transaction. Another one that's quite relevant here in Michigan, the Rural Electrification Act of 1936, that started the co-op movement. What happened, so much of the development of the industry occurred in the concentrated urban areas, and the farm community was not well served, because it costs too much. It's like the Representative LaFave's question. Extending that power out with just a few customers is expensive. And so the farm community wasn't being served, so the Congress came up with the Rural Electrification Act to basically facilitate a massive expansion of the grid to cover the farm community, the rural communities, and it was done through financial incentives, low-cost loans, things like that to build these systems. And today's Michigan co-ops are the outgrowth of that. And they do tend to serve the rural areas primarily. And the Rural Electrification Administration, REA, was under that. And then you had a series, public power grew tremendously during the Depression as part of the national effort to generate jobs through the WPA and projects like that. So you had the Tennessee Valley Authority was under federal statute, the Bonneville Authority, which is the Columbia River Hydro in the Pacific Northwest, massive systems, multiple dams, Hoover Dam, and by 1941 you had 12% of the total country's generation was under public power, these public works projects. And the Tennessee Valley, being the closest to us, it's a pretty interesting story because we talk about the UP a lot and the desire and need for economic development. Tennessee Valley Authority was exactly that. This was a very impoverished, rural, lightly inhabited area, and the government decided to step in there and develop electrification through it started as hydroelectric. Now they own all types of plants, but these projects, and if you ever drive through Knoxville, Tennessee, you see it. A lot of these reservoirs, they've now developed retirement communities on them. If you like to see the lake level go up and down a lot, but it was successful. It really spurred the economic growth that you had in that Appalachian region as a result of the low-cost power from the TVA projects. And in the Pacific Northwest, same thing. The Columbia River hydropower, once you build it, is inexpensive because you don't, like solar and wind, you don't have the fuel cost associated with it, and it's a good peaking kind of resource too. So it's in the Northwest Pacific, if you look at rates and do those comparison charts, you'll see the very cheap rates there because of the massive hydro projects there, and they even feed into California. It was controversial at the time, though, and I threw in this quote I found just because I thought it was funny. Wendell Willkie, who was then an investor-owned utility president, became political figure too. Because of all the massive investment in the TVA, he had this quote, "The Tennessee River touches 7 states and drains the nation," because you were having federal subsidy for one area. So that was interesting. It wasn't without controversy. Michigan. Right at the end of the Depression, the Public Service Commission Act, and this is now remains the main act for regulation in Michigan, the primary statute that governs the MPSC. Some of the subsequent statutes, typically like Act 341, just in 2016, amend Act 3. So this is now the platform for Public Service Commission regulation, and there have been a series of significant amendments to it. But that abolished the Public Utilities Commission and went back to a 3-member board with 6-year terms. And the third bullet on the slide, it was interesting because I remember seeing that when I was a young attorney, and you'd open up the statute books and you see this recital that was in Act 3 that the Public Utility Commission, having failed in its duties to the public, it was clearly a big political fight, and I didn't have enough time to track it down. I think it had to do with something unrelated to the electric utility business, but they abolished the entire commission and started over, basically, is what happened. And the basic provisions of regulation are included in there, the regulatory process, how cases are conducted, the need to have cases. Eventually, by amendment, your power supply adjustment clauses get in there, consumer representation, and quite a bit more that we're going to talk about later. And then kind of some of the main changes were the 82 Act 304, which was the adjustment clauses, 2000 Act 141, retail choice, and the 2016 Act 341. They're all big amendments to Act 3. So Act 3, 1939, still the main. So we talk after the Depression. This is what I think gets relevant to the current situation to some extent, and we had decades of basically uninterrupted growth in the electric industry. And these are some kind of examples of the first, on the left, the picture. I wanted to find a quote that's too cheap to meter, because everybody said that about nuclear power back in the 50s and 60s, the growth of atomic power. And this slide had this kind of bizarre picture of an atomic power plant envisioned by someone, the one on the left, and it has that quote, "Electricity too cheap to meter." It didn't quite turn out that way, did it? But the next one is on the barricade there, "Dig we must." That was the slogan of Consolidated Edison in New York, which was always digging up the streets to expand the grid. And they had adopted that as their kind of major slogan. Now they've gone to clean energy today, but that for years that was the slogan. It just reflected the fact there was always so much activity going on with the rapid and continuous growth of the electric grid and system. The third one there is just one of the TVA hydro dams. And then the fourth one, this character that we used to see a lot back when I was a kid, I remember more, is old Ready Kilowatt. Was his name. Ready Kilowatt, ready to go to work for you. And it was constant promotion of the uses of electricity that were always increasing that fueled this growth. I think one of my members, Excel Energy, owns the rights to Ready Kilowatts still to this day, but it's not something you see very much anymore. In Lansing, they used to have, when I first came to Lansing in '79, on the parking ramp, the South Grand ramp, there was a giant neon, I think it was, sign. It's electricity, it said, that the Board of Water and Light had up. And that was kind of a holdover from the promotional days as well. And Michigan power plants, there's a lot of them that were built all through this period. This slide I've got, these are just pictures. The Edison Sioux Electric used to be the IOU at the Sioux, but now it's Cloverland Co-op that took that over. That plant was built very early in the 1900s, and it's a very unique hydroelectric facility generating off it's about a 30 megawatt roughly plant, so it's one of the bigger hydros in Michigan, might be the biggest. And there's another one in the river near it called the Army Corps plant. So that's, in the early days, and Union Carbide was part of this. They built plants for industry, particularly true in the UP. The Board of Water and Light plant, this is the Eckert, that's probably going to close down in a couple of years, right down to one of Lansing's distinguished landmarks, those three stacks. That plant, originally when it was built, there were no stacks. It had openings at the top of the brick part where the smoke would just come out. Things progressed, with the pollution control measures then. And then that third one there on the left is the Cook nuclear plant, which is Indiana, Michigan AEP, one of the larger nuclear plants, over 2,000 megawatts, over on the shores of Lake Michigan, started generation in the 70s. 2 units there. And then, probably the unique thing about Cook, which didn't happen very much longer after that, they used Lake Michigan as the cooling tower. You used to see in nuclear plants with those big cooling towers, even some coal plants use those, but in this one, in that era, they allowed them to use Lake Michigan water in and out for the cooling water for Cook. You're going to lose this one on the upper left is the St. Clair DTE plant that's had an incident last summer, and that one's going to be one of the ones that's going away in the next few years. And then I took this wind picture back when my assistant's husband was a crane operator. This was a few years ago, and he called us up one day. He said, "You wouldn't believe it, I'm working on a grain elevator in Breckenridge, and the wind turbines are growing out of the fields like crazy." So we drove up, and I took this picture. This was I think it might have been the Harvest project. It was a co-op project up, and as you go up now 127, you didn't see it like then, but now there's all those wind turbines you see going up there. That was one of them. So over time, Michigan developed its whole fleet of power plants as this growth continued. And I want to kind of talk about the economics that resulted from that.
Jim?
Yes.
Representative Lisinski?
Yes.
Thank you. Just before we move into the energy crisis, and reflecting on all the power plants that were built as we either heeded the message of Ready Kilowatt and started to use more electricity to make our lives more efficient and economic and livable, quite frankly. So reflecting on where you got us to at this point, And the idea of a regulated monopoly versus I agree, the word competitive and monopoly in the same sentence don't make sense, but a monopoly that happened because of business practices, but an intentional monopoly, an intentional regulated monopoly. Do you think up to the point that where you've gotten in this presentation now, that served our nation well?
Well, yeah.
That
I was
idea of
gonna-
not duplicating assets, not duplicating, served our nation well in terms of prosperity.
These next couple slides are going to show that. And part of it is going back to at the beginning of this, when I was talking about the financial stability, by allowing a monopoly and allowing, a regulated return, the rate-making formula, you provide a lot of financial stability because these are long-term assets, 40-year lives, 50, 60-year. I mean, look at the Edison Sioux Hydro, that's 100 years plus now. So when you're investing in that, investors want the stability and knowing that they're going to have an income stream to pay off, the debt, to keep the utility financially healthy. And of course, it comes from the customers, the revenue. But yeah, and here's the example. I mean, this slide, you got increasing efficiency and falling prices. This is really a fantastic story, and unfortunately, we've kind of reached a little bit of an end to it that we'll get to. But Pearl Street, 1882, 24 cents a kilowatt hour. These are nominal dollars. 138,000 BTUs per kilowatt hour. So it took a lot of burning coal to get that generation. By 1900, residential rates at 17 cents, 92,000 BTUs. So already you're seeing efficiency rapidly coming into the system. Again, these are coal-type generators.
And before we go any farther on that, to me, as I look to where we got at this point, the financial stability, there might be some who say you get financial stability by competitive markets. And that provides that an investor would not be willing to invest in a 40 to 50-year asset if they thought they weren't going to get the return on that. That's not substantially different from a competitive market, right? We have folks who build manufacturing plants. We have folks that do things that cost hundreds of millions of dollars to do, but they're betting on their competitive market to provide that. If they are building what needs to be built and what customers want, then you're making the right decision. And
Yeah,
so
that's
for
how
me,
it
it's the
started.
efficient use of dollars and also the obligation to serve. So that idea that our country prospered as a whole because now electricity, through this mechanism, engendered an obligation to make sure that more than just an urban city center was served with electricity.
True. I mean, all that. Now, government's involved in all this because the extension of systems to the rural area took a federal act and took financial stability of a different type, guaranteed by the federal government through the Rural Electrification Administration.
So do you think competitive markets could have achieved that in the 20s, the 30s?
Well, it's hard. That's hard to say because
Yeah.
they did. In the beginning, it was competitive markets. So you had all these different Edison licensed systems or Westinghouse Tesla systems being sold as grid packages. Investors they were betting on the growth of this industry, so they were willing to put up their money, without a guaranteed return, because they thought the overall system, that was going to.
The growth potential was there.
Yeah, it was, and it was. I mean, and this slide shows why the monopoly system over these years of, I think it's like a 70-year period at least, depending on where you draw the line. This system worked pretty well. I mean, because you had growth in the customer demand, and then that would spread the costs over more customers. And then you had the efficiency gains, which this slide shows, as you go from 138,000 BTU per kilowatt hour down to 10,500 by the 1960s. And then you kind of you're sort of bumping against thermodynamic limits to how efficient a steam turbine generator can be. But that's what allowed. You had and so prices. This slide's showing they're dropping 3% a year in the 45 to 50, 1% a year in the 50s, and 1.5% in the 60s. You didn't have the pressure that we have now when this changes, to government intervention to kind of change the structure of the industry. You didn't have it then because everything was growing and prices were dropping under that model. And so, you had, this slide shows the growth rates. I mean, up till 1932, 12% annual growth, 8%, above 8% through 60, 7.5% in the 60s. And that's why all those projects, we kind of ran into a brick wall in the in the 70s and 80s when all these baseload plants, I mean, when I started, you know, I was an assistant AG back in the young days, there had been a whole bunch of projects that were on the books to build like Greenwood Nuclear, you know, in Michigan. And because of anticipated growth at that 7.5% level, and that all stopped with some of the crises in the 70s and the, you know, which I'm going to get to in a minute. But so your electrification on this slide grew from 8% of the dwellings in 1907 to 67% by 1932 in farms, I shouldn't say forms, got to 50% by 45 thanks to the REA. And that's what's going on. So let's see, I gotta pass that. I'm going to get to that energy crisis in a second. That slide's a little bit out of order. Hang on a second. One of the things that happened, well, I'll start with that. This is, I just wanted to show, you know, this is getting into the 70s and what happened, some of the things that happened. The 3 Mile Island accident, which was just terrible for the nuclear industry at the timing of it. The gas shortages from the different energy crisis, which I've got in the outline. I just threw these pictures up, and I don't know if you recognize Jane Fonda, but this was just one of the bizarre coincidences that ends up having a huge effect, you know, in the public mind, was the movie The China Syndrome. How many of you saw that? Anybody remember it? It was a very, it was about a nuclear meltdown, and it was Jack Lemmon and Jane Fonda in Pennsylvania, a utility having an actual meltdown because the control room cooling water gets too low and the fuel rods melt. It just happened to come out, just by bizarre coincidence, right at the time of 3 Mile Island. And so, you know, you talk about changing public perception from too cheap to meter to that's our future to between that, you know, Chernobyl, I guess, at the time, you know, a little bit later. I mean, it was devastating to the development of the nuclear industry, which was going to be our kind of non-polluting, low-cost, because the fuel cost is so low, the density is so good, resource, and it's amazing what things can happen in the world that change public perception. And the I'm going to talk a little bit about the increasing the energy. Let's see. Nope, don't have it there. It's in page 7 of the outline. Increasing costs in the energy crisis of the 70s and 80s. This is what happened, and this is what really led to the push for competition and everything. The marginal costs begin to exceed the average costs in the business, and the factors that affected that: inflation, labor costs, fuel costs rising rapidly, environmental concerns, the entire environmental movement. I probably don't do enough justice to that in this presentation yet. It started to grow in that era, and then public opposition to projects, which started with the no nukes kind of campaign, but you know, increased after that. The Arab oil embargo of 1973 after the Yom Kippur War was just a huge shock to this country, and I remember being a young driver then, and the gas lines and the rapid increases in gas prices. You know, power plants had gone to oil to some extent in those days, and that all changed. The oil crisis then of 1978 to 80, the Iran hostage crisis, precipitated another problem. 3 Mile Island, I've mentioned that. And then generally fears of resource scarcity and peak oil. Back then, in the early 70s, I was a resource development major at Michigan State, took some classes in this, and they talked about how we had a 10-year supply of natural gas, and then it was all over. Oil was about to, you know, was going to run out. All we were going to see on the horizon was rising prices and misery as the energy business was just on a terrible path. Amory Lovins, who I mentioned in the slide here, he wrote this article about the soft path, and it was in the October 1976 version of Foreign Affairs, about conservation. This article had a lot of influence, particularly in California, about bringing in conservation, efficiency, and all that started because of this energy crisis and got into the federal policy. Now in Michigan, one of the things that happened was the Administrative Procedures Act of 1969, which we had a number of, this is relevant to utility regulation. There was a Federal Administrative Procedures Act in '46. This is about rulemaking. And then there was a lot of desire for open government and more access to government, more due process for people participating in proceedings. And this led to kind of a modernization of the Administrative Procedures Acts from earlier acts in Michigan to the 1969 PA 306. This act governs rulemaking at the commission. It actually has a number of things: agency guidelines, formal rulemaking, the JCAR process that you probably have to learn about being in the legislature, emergency rules, procedures in contested cases, licensing and judicial review. All those things are covered by the APA. When you hear about commission cases, they're trial type cases in rate cases and others where you have an administrative law judge who writes, here's the evidence. It's just like a trial, objections, discovery, all those things. And then they write a proposal for decision. That's right out of the APA, which is a recommended decision that then goes to the commission for their final action. That's all still in effect today, and it came out of the 1969 APA. So the rulemaking, which is quite cumbersome, we get involved in that a lot at Mega, and it takes over a year usually for anything, just about. You have to have public notice, you have to have public hearings. There has to be justification of the, at least some exploration of the cost of the rule that are imposed. So all of that is quite relevant. Another statute I definitely wanted to cover in this early session was 1972 PA 299, costs of regulating public utilities. Now prior to this, the legislature would appropriate costs for the commission, and that's how they funded regulation. This one basically developed a method of assessment through the public utility rate structure to finance the costs of regulating public utilities. So this statute governs it. A lot of it has to do with the apportionment. They take all the utilities that are regulated by the commission, and at the time in '72 there was quite a bit of other telecom regulation was a huge part of it. And so, and the co-ops, rate making, all that was part of this. And they would apportion it based on the relative levels of regulation of these different entities, usually by gross revenue is how they looked at it, at first with a few exceptions. And then they had procedures. Utilities get assessed every year on under this statute for the costs of regulation, and there's procedures where you can challenge that. We just had one last year where the AT&T challenged it at the commission, asking to have theirs cut in half because there's been so much telephone deregulation that there really aren't the level of burden on the commission that it used to be, and the commission ended up granting that in a case. And because of that, we were in the case. I looked at the funding, so I got the 2017 numbers just to show you how this works. About $34 million total for the cost of regulation, and that gets divided up among the PSC and the Michigan Agency for Energy get most of it, $27.7 million. These are rough numbers, approximates. LARA, the agency itself, for their administrative support gets about over $4 million, and the Attorney General, which is a party to the cases and represents the commission staff, they get $2 million. Some of that goes to the administrative law judges and things like that. So this is how they fund the costs of regulation, and it's done through an assessment to utilities through the structure. And an example of, I think the assessments came out just recently, and when the new statute passed and they added money for the intervention funding, that gets assessed as well to the utilities.
Tim, I've got a question for you. In the first bullet point under cost of regulating utilities, you say there's a dedicated fund, use of the funding, specifically to finance the cost of regulatory public utilities. Michigan Agency for Energy is a recent creation of the executive branch. Is it statutorily authorized to take those funds?
I'm not sure I can answer that. I mean, the question occurred to me at the time, but I do know that, for example, when they set up the MAE, they moved the customer service group from the Public Service Commission over to MAE, and they're pretty intertwined with regulation because they handle the public complaints under rulemaking and things like that, that utilities have to deal with a lot of that, but the commission has their own group that does that. So they went over to MAE, so that's part of regulation. I mean, I don't know that I heard much debate about that question when it happened, but the statute says the costs of regulating public utilities. That's pretty much what it says, so.
And members of the committee, we got about 6 minutes, 8 minutes before we adjourn, if you've got questions for this week's session.
Questions?
Go ahead, Jim, if nobody does.
Okay, I'll cover one more thing then that was quite, and I'll pick up and finish the rest of this, next time, but utility adjustment clauses, we're back to the early 80s. This was a time of, the fuel costs were growing like crazy. This was part of that era of the energy crisis, kind of the tail end of it. And there had been fuel adjustment clauses in utility rate structures that basically allowed utilities in between major rate cases to adjust rates upward, it was upward, to recover for increases in like coal and other fuel costs that were happening pretty rapidly in that era. And that generated tremendous outcry in Michigan, a very public debate over whether what they called automatic adjustment clauses should be allowed. And there was a movement, a customer movement, a citizen movement to ban them. Politicians, Howard Wolpe had a committee that investigated this. So it ended up in this statute, but not without a lot of controversy. There were 2 ballot proposals. One just banned automatic adjustment clauses completely. That was Proposal D. And then the other one was Proposal H, which allowed this, what ended up becoming the method. It had to go to the Supreme Court, though, because both ballot proposals passed, and they had to decide a case, went all the way to them to decide which one goes into law then. And it ended up the one with the more votes, which was Proposal H. Now, Proposal H led to 1982 PA 304, which is established the framework to adjust utility rates in between rate cases to reflect changes in the cost of gas for gas utilities and power supply for electric. And this is the familiar, you've heard GCR, PSCR, that's gas cost recovery, power cost recovery, annual proceedings the commission has. And the big gain for the protestants, I guess, was that this became a public process with notice and hearing, so they couldn't do it automatically. The utilities couldn't do it. They had to have hearings on this. And this led to the start of publicly funded ratepayer intervention, because one of the trade-offs on this statute was they set up the Utility Consumer Funding Board or Participation Board. Jim McGinnis runs that today. You've probably heard from him. Yep. That funded mainly for these kinds of cases. It was limited to Act 304 adjustment clause cases for years until the 2016 Act has expanded that.
Jim, Vice Chair Lisinski has a question.
Yes.
Quick question. When we're looking at these fuel cost adjustments, way back in the beginning, you explained how rates were set, the rate of return, so that there isn't a public taking. My understanding, I want to see if I'm correct here, is that when if it was calculated in that the cost of gas was $1.50 a gallon, and and it's risen to $2 a gallon, that fuel cost adjustment, that 50 cents that plays into it, does not have a rate of return applied to it. It's simply cost of fuel. That's right. Utilities can't game the market and say, oh, look over here, I can buy fuel for $2 instead of $1.50, and I'll get my 10% on top of that $2. Is that correct? That there's no...
Your return is only on the investment base, the rate base, as they call it, which is not your operational cost like fuel and purchase power.
So it's still to a utility's benefit to use the lowest cost fuel. It's not to their benefit.
Oh, yeah.
They don't get a bigger rate of return because they're using a high... Does that make sense to you?
Yeah.
Because if your return is on your cost base and
prices,
you're growing your cost base.
It's always in your benefit to try to reduce those costs as much as you can. I mean,
Okay.
even then, in those days, coal had been a stable cost resource for a long time, and even after that, it became that again. But in that day, there were rapid price hikes, and so they were just trying to keep up with it, to avoid. But yeah, there's no return on the cost of your purchased gas or your electric fuel. The fuel for the power plants, basically, is what that is.
Okay. So the consumer outrage was really around prices all around them were increasing, not on
It was motivated by, yeah, I would say that's probably right, but it was directed toward, I mean, utilities were a target.
Right.
Nuclear power, pollution, the environmental movement, I mean, and this type of thing, you're sticking us with a monthly rate increase, and we never even got to be heard, that kind of
Okay.
thing. But they took care of that with the notice and hearing, and these things have continued till the present day, and I think I'll stop right there, because
Okay.
rather
Well,
than
thank
jump
you
into
for that
another one. So you've
clarification.
gotten quite a ways forward to the statutes, but I haven't gotten to the 2000 Act, which, and the lead up to that, but I guess, and all of this, I think, is important to an understanding of where we are today, so, and thank you for your patience and for listening.
Representative Griffin, is this what you had in mind?
Hey, this is great. I wanted to sell popcorn, and I'm all
Okay.
excited over here, so fantastic, thank you.
Representative Johnson has a question.
Thank you, Mr. Chairman. You talked about peak oil. Were the experts in that field at that time in pretty much agreement that peak oil was a thing, or is that 50-50, or is that a minority view?
It was an ascending view, at least in those days.
So most people did believe, most of the
I
experts
don't know about
did.
most people, but a lot, yeah, there was King Hubert was the guy, he was a geologist for Shell, and he was the one that really, so he's a big oil guy, and he was the one that promoted that theory originally.
So the experts get it wrong a lot of times on this type of stuff.
Oh, on anything, yeah, sometimes they do.
Good to know.
Sure.
Representative Lauer.
Thank you, Mr. Chairman. Just a quick question for you. Proposals D and H, who put those on the ballot?
The utilities were, there was I can't remember who D was. That was the one that totally.
I guess what I was asking, was it a signature campaign or was it the legislature?
Signature campaign, I think, for D, and I think it was both of them.
Both was
Initiative
signatures.
and
Okay.
and referendum. They were.
Thank you.
Need a motion to excuse Representatives DeAnda and Garrett. Vice Chair Lisinski so moves, without objection so ordered. Members of the committee, there's a news conference in the Speaker's Library at 10 a.m. regarding no-fault insurance, if you wish to attend that. And we will adjourn now and reconvene with the second presentation by Jim, and hopefully Laura Chappelle can join us next week. Same time, same channel. The Energy Committee is adjourned.